Justice?
I, too, just have some questions about the limits of your argument. So in our colloquy earlier, did I understand you correctly to say that even if this is a mixed question, even if in theory Guerrero-Lasprilla applies here, permitting judicial review of the application of law to facts, that there's still a category of claims that a non-citizen might press on review that really are purely factual?
I don't think that's what I was intending to say, Your Honor. My argument was that if in a court of appeals a non-citizen presses purely factual, challenges findings of historical fact, those will be unreviewable, and a court of appeals can just say, we aren't reviewing that.
Okay, that was my question. So you're saying,
yes.
Okay,
yes. My apologies if I misunderstood.
Okay.
Definitely unreviewable under Patel.
Okay, but you are saying, and I think this kind of came out when you were talking to Justice Jackson, that while the hypothetical that I just posed, like, does your son have a mental illness or not, that's an unreviewable fact.
Right.
But you have said that the weighing of those facts, which one might be more important than others, or listen, I accept that your son needs your emotional support, but I also accept that his grandmother cares for him, say, and so I just don't weigh it that heavily. Is that a factual question, or is that a mixed question?
I don't think that is a factual question. I think it has to go into the overall analysis, whether the non-citizen established exceptional and extremely unusual harm. So I think that weighing might be viewed very differentially because of the proximity of the IJ to the facts and experience, but it wouldn't make it unreviewable. And I think here, for example, we would say, Your Honor, that the IJ really erroneously boiled the entire analysis down to economic detriment, which is not the way that you're supposed to apply the statutory provision. But any type of weighing would certainly be viewed deferentially. I just don't think they'd be unreviewable.
Well, I guess I don't understand that. I mean, I agree with you if say the IJ said, listen, all that matters is economics, and we'd say, well, that was a misunderstanding of what the hardship standard requires. I mean, I can see why that's a question of law. But when you're talking about the weighing, I mean, let's say, I credit your testimony that you have a strong emotional bond with your son and vice versa. I also have testimony here that I also credit that the grandmother cares for him. I'm just making this up. I know it's not your case, but that the grandmother cares for him, and there's a strong emotional support there. And so I just think given those two, I just don't think that the emotional support is enough that the father provides is enough of a reason to say hardship. But you're saying that's a legal question, that kind of way?
I'm saying that constitutes a question of law as interpreted by the INA, or as the INA uses that term, and that all of that would cash out under the standard of review analysis.
Okay, and then last question. You have said in response to Justice Kavanaugh's questions that the standard of review would be deferential, and you initially said abuse of discretion, and so I just want to clarify, is that what your position would be?
So, there are various kind of articulations of deferential review. We haven't briefed that, and so I suspect it would be abuse of discretion.
Okay, but you're not making a commitment. You're saying you suspect, but maybe it's clear error.
It might be. I mean, Your Honor, I would just say that would, I'm sure, be briefed and has been briefed in other cases, and we just haven't here. But I do believe that it would be a deferential standard of review. It's, when you kind of layer the standard of review onto the administrative law context, there's lots of ways you could articulate what that standard is. But due diligence has been reviewed for abuse of discretion since Guerrero-Lasprilla.
Thank you.